As lawyers continue with their heads of argument in the Esidimeni case, Advocate Ebenezer Profi, who represents the Ubutle Nkosi and Mosego NGOs, argued that the patients who were under his client's care died of natural causes, even though the circumstances surrounding their deaths remain questionable.
I agree with the evidence leaders in respect of docket 86 and docket 102 that no living can be held responsible for the cause of these deaths, so there's no need for further investigation or submissions in that regard.
Both NGOs have been fingered in the tragedy, but their lawyers have argued that the Life Esidimeni management failed to provide detailed and correct medical records for each patient.
Even when the expert panel report was conducting their investigations, she confirmed that even at the tail end of the investigation, the clinical records made available from Life Esidimeni were often incomplete. So there's nobody before this court that ever received complete medical records from Life Esidimeni.
But evidence leaders say if the moving of patients had been planned properly and all medical and relevant documents had been submitted to the new locations, they would have been able to foresee the problems that would arise and deal with them before the Esidimeni patients lost their lives.
Foreseeability is important in respect of the only two offences, criminal offences, which may be relevant to this matter, and that is either murder or culpable homicide. Both involve foreseeability as part of the test.
Last week, Civil Society Movement Section 27 asked the court to criminally charge former Gauteng Health MEC, Gedani Mahlangu, for the 144 deaths. In her testimony, Mahlangu had said she terminated the Life Esidimeni contract following pressure from provincial heads to trim the fat from the bulging health budget. The inquiry continues.